You may be seated.
Good afternoon. Good afternoon. Welcome
To the spring moot court competition at Baylor Law School, sponsored by Faegre the Drinker. Faegre Drinker is a large firm located principally in Dallas for our purposes here. And we are so delighted that the firm some time ago agreed to sponsor this competition. I think as everybody in the room knows, at Baylor Law School, advocacy is a really big deal. It's a center core of what we do here and what we're known for. We have a wonderful curriculum that goes across business and transactional law, criminal law programming and the like. But as you come into the law school as 1Ls through those first 3 quarters, you're introduced, of course, in property contracts, torts, but you spend a lot of your time beginning to experience what it's like to be a lawyer. And of course, that occurs through our LARC 1, LARC 2, and LARC 3 process. The competition this time involved 42 teams from the 1L ranks. And I don't think we had any 2Ls or 3Ls. We often do. But we had 42 teams compete. And of course, this has been something that's been going on now for some time as you have done the brief, as you've done a practice round, and then of course went on to the actual competition rounds. That brings us to today with the championship round. And I first of all want to introduce our panel today. The presiding justice will be Mr. Jude Hicklin of the firm, and also joining from the firm, Mr. David Kent and Mr. Neil Rambin. And then we have also joining us Jennifer Richards of Richards Law and Jessica Underwood of Nix Patterson Law. Our 2 competitors who were the champions in the fall, Catherine McKinney and Maria Zermano, are here today, and they're a lot more relaxed than they were at this moment in the fall competition. The competition has gone very smoothly, and at the end of the program today, we're going to have an awards ceremony. And in the awards ceremony, I'm going to draw out some folks who have been very important in making this all come about, including my faculty colleagues and the officers of the Moot Court Society, the Harvey M. Ritchie Moot Court Society. But we will leave that to the completion of the round. And with that, I'm going to turn it over to Chief Justice Hicklin for the beginning of the round. And each of the competitors today will introduce themselves when called by the court. Thank you very much.
Petitioners, please make your appearance. Would you like to reserve any time for rebuttal? Very well. Are respondents ready to proceed?
Yes, Your Honor. Yes, Your Honor.
All right. Thank you. Petitioners, you may proceed with your argument.
Chief Justice, Associate Justices, good evening, and may it please the court. My name is Aquila Jones, and along with my co-counsel, Rachel Brooks, we represent the respondent in this case, Max Whiteberry. Your Honors, there are 2 issues before the court on appeal. First, whether the immunity to comment K to Section 402A of the Second Restatement of Torts should be applied as a case-by-case basis. And 2, even if a claim for strict liability is barred, can a claim for negligence proceed? I will be addressing the first issue, and my co-counsel will be addressing the second. Your Honor, as we mentioned before, we'd like to formally reserve 2 minutes for rebuttal. Thank you. Your Honors, this court will have to decide whether it will continue to allow blanket immunity for drug manufacturers, or if it will allow plaintiffs like Max Whiteberry to be heard by a jury of their peers. The case-by-case approach is the only approach that aligns with the intent and drafters of Comment K.
When you say that we should continue to allow Do you concede that that's currently the law in the state of Texas, that there's blanket immunity for manufacturers of pharmaceuticals?
I don't, Your Honor, but I'm referring to the ruling from the lower court, the 15th Court of Appeals. And for that reason, we asked the court to reverse the decision of the 15th Court of Appeals and allow Whiteberry to bring his suit for 3 reasons. 1, why this court has not yet decided what to do with design defects. This court and other Texas courts have shown a general hesitancy to allowing blanket immunity for other kinds of product defects. 2, it is the only approach that aligns with the words and intent of the drafters of Comment K. And 3, as a majority of other jurisdictions have adopted the case-by-case approach, they show why Texans are better served by it.
Blanket immunity, but don't you concede that the blanket approach does have an exception for fraud?
I'm sorry, Your Honor?
Is there an exception for fraud under the blanket approach?
Your Honor, I believe there's always an exception for fraud in all kinds of cases. But here, with the immunity for the blanket immunity approach, it's stating that drugs that are unreasonably unsafe, that are not paired with a proper marketing warning, those are the kinds of drugs that should be immune from suit. And so when you look at the Texas Supreme Court, this court, and the Crocker case, while that court was dealing with the marketing defect case, that court did show a hesitancy to allowing blanket immunity by stating some products are so dangerous that the manufacturer should be held strictly liable for the harms that they cause. And when you also look at another Texas court, the Crocker case, which was a Texas Court of Appeals court, also applying and looking at a marketing defect case, that court described all different kinds of the product defects and how its immunity applies. While describing directly a design defect, they said that it may provide immunity, not that it did or that blanket immunity was automatically afforded or that it was given, but that it may.
The federal courts in Texas applied the blanket approach?
They have, Your Honor, but referring to the record on page 25, the Fifth Circuit explicitly stated that Hackett and all of its progenies did not rely on Texas law in applying that case. And they stated they relied only on their own policy decisions and the rulings from other courts in deciding to make that decision. And so when we're talking about specific Texas courts looking at Texas law, there are only 2 cases to look at here that actually describe the reasoning behind the courts, and that is the Crocker and Centocor cases. And they show a hesitancy to the court of allowing blanket immunity for other kinds of product defects.
What about those the federal district court cases, though? What about the rationale in those cases? I mean, those are learned judges who understand Texas law, and they came to the conclusion that the blanket approach is appropriate. What about their reasoning was wrong?
Well, Your Honor, we believe that their reasoning, just as the Fifth Circuit stated, they only relied on their own policy decisions and the fears and rationales from other justices and other states. And what we are asking the court to do is rely on its own courts and its own trend when it's talking about how to apply immunity. This court has not yet decided how to apply immunity for design defects, but following its own trend after adopting the case-by-case approach in the Uniroyale case, which is the case where this court adopted Comment K, it shows a trend of the court for rolling away from just giving blanket immunity.
Specific policy considerations make the case-by-case approach preferable to the blanket approach in your mind?
Yes, Your Honor, so that will take me into my third point. In the Feldman v. Leaderly Labs case, the New Jersey Supreme Court there reasoned that drug manufacturers are just like all other manufacturers, and courts don't afford this level of protection and immunity to any other manufacturers. And so it would be providing a shelter for one kind of specific manufacturer when we just don't do that for anyone else.
Isn't there something unique about drug manufacturers as opposed to, say, washing machine manufacturers, and that drug manufacturers are manufacturing a product that we as society think is really important? It keeps people alive, it keeps people healthy, and so we want to encourage development of new and maybe even experimental drugs, and perhaps allowing for a blanket immunity encourages that kind of development.
Well, Your Honor, we do recognize that there are specific drugs that have products and abilities that help and betters everyone's lives. And Comment K actually addresses that specific fact. In the Hill v. Labs case, the Eighth Circuit reasoned that Common K afforded specific kinds of immunity that should be provided for drug manufacturers, specifically exceptional products. And so there they were recognizing that the value that all drugs provide, but there are only specific kinds of drugs that should be worthy of the immunity that Common K provides. And the Eighth Circuit explained this by going through the history of Common K.
How do we decide what is an exceptional product?
Yes, Your Honor. So in describing the history there, the Eighth Circuit brought up how a motion was brought to afford blanket immunity for all drug manufacturers, and that motion failed. And instead of affording blanket immunity, the drafters outlined and gave a specific example of what they were looking for, and they gave an example of the Pasteur vaccine. So even back then and now, when a patient is bitten and infected with rabies, medical professionals have a specific and limited time to afford them treatment in order to save the patient's life. And the Pasteur vaccine was that remedy. But the downside was that the Pasteur vaccine came with severe side effects, and so they chose this example to show that, yes, you have a life-saving drug that betters and literally saves people's lives, but you ran the risk of having some nasty and severe side effects that came along with it. And so the drafters chose this specific drug of an exceptional product that has exceptional need to the public and has exceptional benefits, instead of choosing to give just automatic immunity to all kinds of drugs.
Well, who makes the decision of which drugs are exceptional and which are not? I mean, the Court of Appeals here said this drug, in this case, qualified for that type of protection, didn't it? By granting immunity?
They did, Your Honor, but we believe a jury is better suited to make that decision and to weigh which kinds of drugs should be afforded that immunity instead of applying blanket immunity for all kinds of drugs. And
doesn't that open up the manufacturer to inherent uncertainty that will discourage innovation, and it will discourage marketing? And so the next Pasteur's vaccine will never show up because we have no certainty. We're letting a group of jurors who have the education of a fifth grader, if we're lucky, to make that decision, and you're thinking that's a good policy?
Well, Your Honor, I'd like to address your answer in two parts. One, we do believe that Texans have the ability and Texas jurors to answer and handle this case. We ask jurors to handle all kinds of complex cases, including those like antitrust laws and antitrust cases. And while that is a complex system and the science and the math and what you're talking about for the drug here in Target-all, we also believe it's a concept, the pros and cons of each side is something a juror and every juror will be able to understand. The risks of what you're explaining, Your Honor, of having a drug removed from the market compared to spurring innovation, what you brought up, Your Honor, these are also drugs that the patients and the jurors actually take.
Wouldn't it make more sense, though, to have the prescribing physician be the gateway for the consumer to determine what's safe, what's not, what it makes sense to use versus handing those kinds of decisions to a jury?
Well, Your Honor, we believe that doctors and the FDA do play a role, as they always do, when kind of determining what drugs are safe and for an individual patient. But when a patient is harmed, we believe that a jury should make that determination of whether or not that drug is unreasonably unsafe, because they are the ones that, I'm sorry.
If we do the case-by-case approach and potentially open up this manufacturing companies to more liability, won't that potentially increase the price of those drugs so they have a cushion in case they get sued? And won't that affect the people that need those drugs, especially if they don't have the money to get it anymore?
It could, Your Honor. But the FDA also regulates different kinds of organizations. Take, for example, food manufacturers. If a manufacturer creates a product that is deemed safe by the FDA and then turns around and harms a consumer, they can be held strictly liable for the harms that food product can cause. And so while it could spur innovation or could raise in other costs, those are the same considerations that every other manufacturer has to take into account.
Are they? Because we're talking about unavoidably unsafe products. You can make food safe. It's not a question of whether people are going to get poisoned, a certain percentage are going to get poisoned. In the drugs, we know there are going to be a certain percentage, unavoidable, who are going to have adverse reactions. And that's why we need immunity.
Well,
In all these other products, examples you're giving us?
Yes, Your Honor, but the case-by-case approach and comment K affords room for that distinction. Only exceptional products like the Pasteur vaccine, and we don't believe that you will be able, or you can determine whether or not a drug meets that same level as an exceptionalism as described by the drafters and as adopted by this court without looking at each drug on an individual basis.
Let's go back to the unavoidably unsafe. Whose burden is it to prove that?
Your Honor, we believe that the defense has the burden of proving that a drug is unreasonably unsafe.
Despite the statute in Texas that puts the burden on the plaintiff?
Well, Your Honor, are you referring to, Section 82.005?
Yes, in products liability law in Texas, then the plaintiff has the burden of proving a safer alternative. But you're saying now that the defendant has to prove that it's unavoidably unsafe?
Yes, Your Honor. So that statute does not strictly prohibit the court from treating comment K as an affirmative defense. It says that the defendant, excuse me, Your Honor, I'm running out of time. Can I finish your answer, please?
You may
Thank
proceed.
you, Your Honor. So when you're talking about Section 82, the statute does not strictly prohibit the court from crafting its own rules in this particular case. So you can have a situation of where the plaintiff still has to prove a safer or an alternative design, and then you can have the defendant still having to prove that it's unreasonably unsafe. So Section 82 doesn't explicitly prohibit the requirement of having both simultaneously, Your Honor.
Chapter 82 give certain manufacturers the presumption that they are unreasonably unsafe, but excludes from that presumption manufacturers of pharmaceuticals.
It does, Your Honor.
How should we look at the legislature's determination, policy determination in that case, as applicable to whether or not courts should adopt comment K?
Well, Your Honor, we are asserting that this case, or this court specifically, Your Honor, may I answer your question and briefly?
Please finish your answer.
Thank you, Your Honor. So we believe that this court in the Uniroyale case adopted comment K and Section 402. And Texas courts and this court alone have already been applying it and following the directives of comment K. And so while that may be the direction that this legislature has gone, we believe that in order to stay in accord with how this court is already treating other product defects, that the trend should be trending away from affording blanket immunity. Your Honor, we ask that you reverse the decision of the 15th Court of Appeals and allow Max Whiteberry to be heard by a jury of his peers. Thank you.
Thank you, counsel.
Chief Justice, Your Honors, may it please the Court. My name is Rachel Brooks, and as stated by my co-counsel Aquila Jones, we represent the petitioner, Max Whiteberry. I will be addressing the second issue before the Court, whether Max Whiteberry's negligence claim may proceed even if his strict liability claim cannot. Your Honors, modern medicine is fast-paced. The state-of-the-art knowledge of the healthcare industry is constantly changing. And in the last century, drug manufacturers have transitioned from wily sellers of snake oil to some of the most trusted professionals in the nation. Consequently, Texans and their doctors rely on drug manufacturers every day to produce medications that will protect their bodies and their futures. When instead, drug manufacturers make decisions that exacerbate their ailments, Texans feel rightfully betrayed, especially when those decisions are based on profit motives and the prioritization of economic gain over human health. Your Honors, today, we ask you to reverse the decision of the 15th Circuit Court of Appeals in favor of Max Whiteberry, such that his claims may be heard before a jury, for the following three reasons. First, Texas law does not expressly bar negligence claims against the manufacturers of drugs. Second, Max Whiteberry's negligence claim is intrinsically different from a strict liability claim such that it cannot be subsumed. And third, the consequence of barring immunity in this case is offering drug manufacturers an unwarranted immunity from suit. Today, this court has the opportunity to hold drug manufacturers accountable to Texas citizens because negligence is not expressly barred by Texas law.
To your point number 2, and can you walk us through how it is not subsumed by the strict liability claim?
Absolutely, Your Honor. So this court adopted, a lower courts in Texas recognized the action of subsummation in the Sean T. Meehan Corp. Case, and that case suggests that when there is a strict liability claim and also a negligence claim, when those two claims are resolved on whether or not the drug is found to be defective, the negligence claim can be subsumed by the strict liability claim. But the court in this case explicitly stated that when there is no negligence other than conduct relating to whether the product was unreasonably dangerous is when subsummation is proper. And when there is conduct relating to something other than just whether or not the product is unreasonably dangerous, then a negligence claim can succeed on its own merits and does not rely on the resolution of the strict liability claim.
Why don't you tell us here, counsel, then, what is the conduct that you are alleging the defendant is guilty of that gives rise to a negligence claim that is separate and apart from what you're alleging with respect to your strict liability claim?
Absolutely, Your Honor. Today we're alleging that the conduct and the decisions made by Fussmeyer Pharmaceuticals that are based on profit motives are different from specifically just whether or not the drug was defective. So here we're looking at not just the drug itself, but we're looking at the phase of time that occurred before the drug was even put to market, when we're looking at the FDA approval program that was going on between Fussmeyer Pharmaceuticals and the FDA, at which time Fussmeyer Pharmaceuticals knew that Targetol Next, the drug that they deemed to be marketing later, was a safer for patients as far as incurring long-term acute kidney damage. And they also knew that Targetol, the product that they were also trying to get approved by the FDA, created a twice as high likely risk that consumers would incur kidney damage from taking the drug. And so when they knew that knowledge and they put those drugs they discussed with the FDA, and the FDA said that either drug could be approved, they decided to put their money and their resources into putting Targetol onto the market first, even though they knew Targetol Next was a safer alternative at that time.
Well, making decisions based on profit, that alone isn't negligence, is it?
Well, Your Honor, we're suggesting here that the decisions are based on the reasonable standard of care that this court adopted in the Gonzalez Caterpillar Tractor Co. case.
Sure, but making a decision based on profit is only negligent where a product turns out to have been defectively designed and then hurt someone, right?
Yes, Your Honor. It can only be determined that the negligence claim can only proceed where there is a cause, but here there can be found that the drug itself caused the harms of the plaintiff without finding that the drug necessarily was defective, because whether or not the drug was defective, the drug caused the harms based on the fact that it was put to market, and those decisions that Fussmeyer Pharmaceutical made in those early stages are what led that drug to going to market to establish that cause element. But if both of these claims were to go forward to the jury and they were to analyze these claims on their own merits, if the strict liability claim were to fail and the strict liability were found that the drug was not defective, the jury could still find that plaintiff, or the defendant rather, is liable under negligence based on the decisions that were made and based on their breach of that duty of care.
But if they said that the drug was not defective, then they're saying that the defendant should not have gone with the alternative design, right? Reasonable?
Well, Your Honor, respectfully, we believe that the drug itself can be found not to be defective, but it can also be found that it was negligent for the producer of that drug to have decided not to put that money and those resources into the safer drug. Because when the plaintiff was being told, Max Whiteberry was being told that he could take this drug by his doctor didn't even know that there was a safer alternative design that was out there that could have helped him with his sarcoidosis and not presented such a high risk of kidney damage.
Is safer alternative design also an element of the strict liability claim?
Yes, Your Honor, it is.
Just so I can get this straight, you're saying that a jury could find that this was a defective product because of the danger that it presents to the public with the kidney disease link, et cetera. But at the same time, they would find, they say it's not defective, but they could find that they're negligent for failing to go do the other product and sell the other product that was safer but more expensive. Is that what you're trying to say?
Absolutely, Your Honor. And this is based on a standard of care that exists within the medical field. And this is based on research both out of Caltech and that was presented by the Medical Association of America that stated that drug manufacturers, it is a common trend for drug manufacturers to use the chiral molecules that were used by Fusmeyer Pharmaceuticals for the sole purpose because chiral molecules are unique and that they can be separated into two separate enantiomers, the dextro enantiomer and the levo enantiomer. And by separating out those enantiomers, a producer of a drug can control the effects of the drug on a patient. And so it is a common trend in the medical field to use chiral molecule separation, creating that pure dextro form, which is the safer form in this case, in order to prevent those side effects, those harmful side effects for harming patients. And we believe that—
Counselor, you keep saying it as if it's either dangerous or the other one is perfectly safe, but even the pure one has a higher rate of side effects. Maybe not the same side effect, but different types of side effects. And it requires a higher dose, doesn't it?
Well,
so aren't they having to make a balancing choice here?
Your Honor, on page site 7 of the record, it does state that a higher dose is required for the pure dextro form, but it does not suggest that there are other necessarily side effects that would exist in the pure dextro form that do not exist in the racemic mixture form of the drug.
It says the higher dose appeared to cause a broader side effect profile, which increased the risk of some side effects, although all of the side effects were mild and not life-threatening. But it reads to me like it's more side effects.
Yes, Your Honor.
More people than the mixed version was.
Yes, Your Honor, just to clarify, so the side effects that are present in the pure dextro form that might be slightly higher risk to be present can still be present in the racemic mixture form of the drug. And here we're thinking about side effects that we incur maybe from taking any medication, like maybe you get a headache or your stomach hurts after you take the medication. Comparing that to life-altering, lifelong kidney damage that is going to affect plaintiff Max Whiteberry for the rest of his life. And while we do believe that there is a balancing decision that can be made on this issue, that is an issue that is proper to be decided by a jury, that should go before the jury so that they can decide whether or not there is negligence in this case.
Ms. Brooks, didn't the FDA already make a determination that that this one formulation of the drug was safe and ready to go to market? And by allowing a jury to answer the question of whether this marketed formulation of the product was unreasonably dangerous, aren't we just allowing a jury to second-guess the judgment of the FDA?
Your Honor, we do not believe respectfully that we are asking the jury to second-guess the judgments of the FDA. And we also believe that this is more of a preemption argument that would be up on, if this case were to be remanded, that would be a separate issue. And the issue of preemption is not before the court today. But we also believe that the FDA...
Despite what my colleague had to say with her question, is it your view that a jury is incapable, or do you think sometimes the jury might be more capable than the FDA or can second-guess the FDA? In your experience, is the FDA almighty on these issues?
No, we do not believe that the FDA is almighty on these issues. And we do believe that the FDA is a large organization and they have a lot on their plate. And sometimes they cannot see the end results of all of the decisions that they are made, that are being made. And additionally, the drug manufacturers are the parties who have the most knowledge about the creation of those drugs. And those are the parties that should be held accountable when those drugs harm Americans. So even if the FDA has approved that drug, if we find that the people who produced that drug knew that there were better and safer decisions to make for the people that would be consuming the drug, then they can be held liable in a court of law for their failure to make the decisions that are in accordance with the reasonable standard of care to which they are held.
Counselor, if we find that policy dictates that an adoption of a blanket approach makes the most sense, doesn't it make the most sense to also find that the negligence claim is subsumed by the strict liability claim? Otherwise, there's just a backdoor around the blanket immunity that we provided in the first place.
Well, Your Honor, I would suggest that, respectfully, the strict liability claim and the negligence claim are also different on the grounds that a negligence claim is based on fault. So even if the court were to decide that a strict liability claim is not always proper, it would be in accordance with policy for the court to find that when there is a possibility of negligence claim, when negligence can be proved and it can be shown that the producer of the pharmaceutical drug was at fault, then that negligence claim should be able to proceed, because then the basis of the strict liability claim and the negligence claim are intrinsically different.
And that's what's troubling me, though. The nature of a strict liability claim is the claimant doesn't even have to prove fault. And if we find, no, that kind of claim, that these drugs are so unavoidably unsafe and so important that we need blanket immunity for any of those strict liability claims, why then would we allow a negligence claim?
Absolutely, Your Honor. We believe that the basis for a negligence claim is harder to prove than a strict liability claim. So we believe that it is proper for a plaintiff potentially to, if it is barred, a strict liability claim, for that claim to go forward on the basis that a negligence claim is harder to prove. If they can prove the harder claim, then the defendant should be able to be held liable for the harder claim. Additionally, Your Honor, the negligence claim is a long claim. We've recognized it in Texas law for years. And the strict liability claim arose to make negligence easier, and it would not be proper for the easier claim and the newer claim that has arisen to overtake the older claim and the claim that is based on holding people to the reasonable standard of care that we.
So let me ask you again, what is the specific fact or the set of facts that exist here that you would have to prove to show your negligence cause of action that you don't have to prove for the strict liability cause of action?
Well, Your Honor, here we're looking at the financial decisions based in this case and the conversation that Fusmeyer Pharmaceuticals had with the FDA, in which they stated that they were planning to first market Targetol and then later market Targetol next in 7 to 10 years when it would be more financially viable for them to put that drug on the market. And that decision is not in accordance with the standard of care that exists within the healthcare industry, which expects people to go ahead and make those decisions based on the chiral separation and to be producing drugs that have a more safe effect on the plaintiffs.
Well, now you keep talking about it was financially motivated, but the financial motivation here is that it is less expensive to produce the combined drug and therefore 1/3 the cost of the pure drug. So where is the profit motive there? They're actually serving the community, aren't they, by making a drug available that the FDA has already approved as safe and effective. So where is the horrible financial motive that you're impugning?
Well, Your Honor, here the negligence is based not just on the decision to market that drug, but also the decision not to put funding and resources into the safer alternative form of the drug. And while we do believe...
Your assumption there is that they could be on the market at the same time. And the record shows it would be 7 to 10 years before the cost would drop on the pure form to get down to where they could market it.
Yeah, Your Honor, we do not believe that they did not have the ability to... Do you mind if I answer the question? Thank you, Your Honor. We do not believe that they could not have possibly put the drug to market just because it is more expensive in an industry that is highly profitable. That doesn't mean that there's no possibility for them to still turn a profit on putting that drug to market. It just means that it would have put a little bit more of a dent in the pocket of the pharmaceutical manufacturers.
Then wouldn't that have made it, sorry, I know you're running out of time, wouldn't that have made it more expensive for the people that had to buy it? And again, that leads us to the people that need it not being able to afford it. So how is this not the better alternative for both the people and the company?
Well, Your Honor, we would suggest that here there is an ability for both drugs to go to market so that the cheaper drug that is more affordable to people can go out to those people. But then the drug that is safer exists and people know about it and can make a conscious decision about what drug they want to put into their bodies. And they aren't holding out for a pharmaceutical company to keep that secret from them.
Thank you, counsel.
Thank you.
Proceed.
Mr. Chief Justice, and may it please the court. My name is Kingry Sullins, and along with my co-counsel, Kelton Munch, I represent Respondent, Fusmeyer Pharmaceutical Company. This case is about protecting the health and well-being of American citizens by ensuring reliable access to beneficial and affordable medication. There are two questions before the court in this appeal. whether comment K of Section 402A of the Second Restatement of Torts applies to all pharmaceutical drugs, and, if it does, whether a manufacturer can still be held liable for negligent design. I will address the first issue, while my co-counsel will address the second.
About comment K, because I've heard a lot about whether one goes with the immunity approach or the case-by-case approach. But I'm curious to hear your thoughts on this. Does this court not have the power to reject the application of comment K altogether here in the state of Texas?
Your Honor, that is not an issue before the court today. There is, in the Third Restatement of Torts, proposition of adopting another approach, but that was not brought up by either party. And instead, the focus in today's court is whether to adopt the blanket approach or the case-by-case approach to comment K interpretation, which is the argument that other jurisdictions that have tackled this issue have had to deal with. And so that is the issue that we'll be dealing with today. And in dealing with this issue, I will demonstrate that comment K should apply to all pharmaceutical drugs in a blanket approach, rather than in the case-by-case method that the petitioner recommends. And I will demonstrate this through 3 points. 1, the blanket approach interpretation to comment K is the trend in Texas courts. 2, the blanket approach allows for more consistent results than the case-by-case approach. And 3, the blanket approach respects the current safeguards of FDA regulation and the learned intermediary doctrine. In addressing my first point, which is that the blanket approach of comment K interpretation is the trend in Texas courts, it is important to note.
Into a trend when we get to make the ultimate decision. You agree that this panel and this court has not made the decision, correct?
Correct, Your Honor.
Precedent on us. We're looking at non-binding precedent when we're talking about the trend, right?
Correct, Your Honor.
So let's talk about the plain language before we get there. What do you do if we just go to the plain language of comment K, and it says there are some products in which it's common in the field of drugs. This is true for many drugs. It didn't say all anywhere in it. It hedged multiple times throughout it. So before we get into trends, tell me about how we're ignoring that plain language.
Yes, Your Honor. It is respondents' belief that this is an unnecessarily restrictive view of comment K, especially when considering the drafting of comment K initially. The drafters initially left the language deliberately ambiguous because they wanted to allow leeway in determining whether jurisdictions should adopt the case-by-case or the blanket.
Counsel, didn't the drafters also, they rejected an attempt to exclude all the prescription drugs from strict liability, yes?
Your Honor, they rejected an outright interpretation of the blanket approach twice, but they kept comment K in Section 402A of the restatement.
The blanket approach has been rejected twice?
No, Your Honor. The express language having a blanket approach was rejected, and the reason was for this was to leave it up to the jurisdictions about whether to adopt a case-by-case or a blanket approach. In fact, the fact that this was so contentious at the drafting of Section 402A of the restatement indicates the importance of this decision, and we believe that since its drafting, there have been policy reasons that reflect the need to adopt a blanket approach rather than a case-by-case method that the petitioner recommends.
Adopt a blanket approach, aren't we just giving kind of a blank check to these manufacturing companies to not be as careful as they can be?
No, Your Honor. That has to do with the language of comment K. Comment K only protects pharmaceutical companies against design defect liability. Marketing defects and manufacturing defects are still very much on the table and still allow an avenue for injured parties to seek redress through that method. So all that is going on today is applying a blanket approach to design defect liability, and that has to do with the nature of pharmaceutical drugs. Pharmaceutical drugs are, as comment K begins, unavoidably unsafe, and this is because of their unique nature, which is why The blanket approach interpretation to comment K allows for more consistent results than the case-by-case approach in courts, because if we were to adopt the case-by-case approach and apply a risk-utility analysis to these pharmaceutical drugs, there would be no sure way of determining whether or not a pharmaceutical drug would pass that, because the risk-utility analysis is such a subjective experience. There is no way of knowing what weight will be assigned to a risk or a utility. And
Wouldn't that be the case for a marketing defect as well? If there's strict liability for a marketing defect, don't you have to weigh whether or not they should have put a risk into the label?
yes, Your Honor, but what we are saying in this case is that the design of pharmaceutical drugs is what makes it unique. And so if someone were to take a drug, we could all have a different unique reaction because of the inherent nature of the drug and the inherent nature of our human bodies. Whereas a risk-utility analysis for whether a warning should be on a label is a lot easier because we can all read the same warning and come to the same determinations depending on the different factors involved about whether or not we should take the drug. So
Why is it important to have a uniform, consistent application, as opposed to letting juries decide just as they do on warnings? For instance, one jury can make a different decision than the next jury.
Yes, Your Honor, and that is the problem, as you pointed out in the petitioner's argument, because pharmaceutical companies won't know what's coming. A different jury could decide a different result about their drug, and it would discourage manufacturing, and this was pointed out in Grunberg v. Upjohn, which is a Supreme Court of Utah decision adopting the blanket approach. It was pointed out in Brown v. Superior Courts, which is a Supreme Court of California case adopting the blanket approach, that if we were to allow the case-by-case approach, there would be no consistency within the jurisdictions as to how the risk-utility approach would be applied to different pharmaceutical drugs, leaving different jurisdictions and even different juries to come to different outcomes depending on how they weigh risks and utilities. And so this is why these jurisdictions have adopted the blanket approach, or one of the reasons why, so as not to chill pharmaceutical manufacturing, because if a pharmaceutical company goes through the long and arduous process of FDA regulation, and then an individual physician prescribes the medication to their patient, and then they are still going to be held liable for a side effect that they properly warned about on their marketing products, then what is the incentive at that point to develop new and different pharmaceuticals for the benefit of the health and safety of Americans?
Balance here, Counselor. Isn't there some manufacturing that we want to chill? State tort lawsuits can play an important role in enhancing the safety and security of prescription drugs, can't they? Otherwise, we run the risk of manufacturers being able to get something through FDA clearance, and then it's over. There's no liability that they could face, even if they've engaged in bad conduct, or maybe they could have used a safer formulation.
Well, Your Honor, to answer that, we would still have marketing defects, which would be most of what would take place in these situations. If something passed the FDA but had a side effect, like with Targetol, in which there was a chance of kidney failure, they would have the obligation to warn about that chance. And if they did not adequately warn, then there would be litigation as far as that goes. And we already have safeguards in the FDA regulation and the learned intermediary doctrine, which is the focus of my third point. Now,
Counsel, if that's your argument, why don't we just get rid of design defects across all of product liability law and just say, hey, as long as you tell people what the risk of your product is, you're good to go?
Your Honor, the only reason why we have this is because pharmaceutical drugs are an inherently unique product that is inherently unavoidably unsafe.
Burden is it to show that a product is unavoidably unsafe? Is it your burden, or is it the plaintiff's burden to show that it's not inherently unsafe?
Your Honor, the Texas law says that it is on the plaintiff to demonstrate a safer alternative design, and that is a major flaw with the with the petitioner's argument, because if we were to adopt their case-by-case approach, then it would be up to the defendant to prove a safer alternative design, and this is in direct violation of Section 82.005A1 of the Texas Civil Practice and Remedies Code, which is...
Doesn't the Texas Civil Practice and Remedies Code exclude prescription drugs from presumption of non-liability? And doesn't that indicate that the Texas legislature has already decided this issue for us?
Your Honor, the Texas Civil Practice and Remedies Code does exclude drugs. However, in Section 82.005E, it says that the section shall not be construed to restrict the courts of the state in developing common law with respect to any product which is not subject to this section. And Texas courts have consistently adopted 82.005E to say that drugs are included in the 82.005A1, superseding 82.005D. And so if we were to adopt the case-by-case approach, this would go against Texas precedent, which, on the subject of Texas precedent, the petitioner has stated that there are only two courts that we can look to, Centacor and Crocker. And while I agree that we should look to Centacor Inc. v. Hamilton to see how the courts have sided in the blanket approach versus the case-by-case approach, I would argue that the petitioners have misread the holding of Centacor. The holding of Centacor advocates for the adoption of a blanket approach, and you can find that.
You've talked about the uniqueness of the drugs and how they're all a little bit different. Doesn't that by itself support that we should do a case-by-case basis instead of treating all these different drugs under the same blanket immunity?
No, Your Honor, because by doing a case-by-case basis, as the petitioner indicated, we would have to adopt a risk-utility analysis. And in adopting the risk-utility analysis, there would be too much subjectivity injected into the courts, so that the weight of what is a risk and utility would be indeterminate. Who decides whether something is a risk or utility and what weight it is given would also be indeterminate. Who has the burden of proof would be in direct violation of the Texas Civil Practice and Remedies Code. In other words, by adopting the case-by-case approach, we have no consistency within the courts, and there is no incentive for pharmaceutical companies to develop their drugs.
Sorry, go ahead.
If I may, on that subject, are you saying that nationwide, all 50 states follow the blanket approach? Or are there some states that do follow the case-by-case approach?
Your Honor, there are states that follow the case-by-case approach. In fact, the majority of states follow the case-by-case approach, and within these majority of jurisdictions, there is no consistency as to how the case-by-case approach of Comment K would be applied.
Well, if that's the case, how did Targetol ever get developed at all? Why wasn't there a chilling effect on the company? Because it said, well, gee, I don't know what's going to happen in Texas, but I sure know that in most states, I'm subject to this varying, inconsistent pattern.
Your Honor, Fusemeyer is a Texas company operating out of Arbrook City, which is seen on page 7 of the record.
They're going to sell this drug nationwide. They didn't go to the FDA and say, we only want to sell this in Texas.
Correct, Your Honor. May I answer your question and briefly conclude? Your Honor, it is true that they developed a drug, and they also developed Targetol next, but they were both approved by the FDA, and Whiteberry's physician prescribed him Targetol. However, if we were to find for the case-by-case approach today, then that would all be for naught, and they'd be facing litigation even though they tried to do their due diligence in getting out a new pharmaceutical drug. While it did not chill them in this particular case in releasing Targetol and Targetol Next, it would definitely do so in any of their future endeavors, and this case would be on their mind of many other pharmaceutical cases. And it is for this reason that I urge the court to affirm the 15th District Court of Appeals ruling and adopt the blanket approach of Comment K interpretation. Thank you.
Thank you, Counselor.
Honorable Chief Justice, Associate Justices, and may it please the Court. My name is Kelton Munch, and I rise on behalf of Respondent, Fusemeyer Pharmaceutical Company. This case is about ensuring that largely effective drugs, such as Targetol and others like them, are not chilled in their development and distribution because of suits arising which are functionally precluded by Comment K to Section 402A. We would ask this court to affirm the ruling of the 15th District Court of Appeals and find that petitioner's negligence claim must fail as a matter of law for three main reasons. First, strict liability and negligence are so fundamentally similar in their analysis in these particular set of circumstances that to bar one and allow the other would result in unacceptably arbitrary outcomes. Second, such a ruling would be consistent with existing local federal precedent on the matter and also state precedent from other states in the country. And lastly, insulating drug manufacturers from liability arising from these types of cases is in the best interest of Texas public policy to ensure that drugs are made affordable and available to Texas citizens. Beginning with the first point, in that in this particular set of circumstances, drug design claims, the analysis for strict liability and negligence are so fundamentally similar in nature that for this court to hold that strict liability may be barred but negligence may proceed would result in outcomes which are unpredictable and arbitrary. Chief Justice, in questioning opposing counsel, you brought up a key point, that it would allow essentially a back door for claimants to, if they fail the strict liability issue, to get around that and go with the negligence issue, despite the fact that the facts between the two are exactly the same.
So shouldn't there be some type of door for egregious behavior or even negligent behavior? Because you said in point 3 that we're worried about affordability and availability, but I'm worried about health of our citizens.
And
when you've got a case like this, where maybe the FDA approved the way that we're talking about it today.
More dangerous drug.
Thank you, the more dangerous drug. But your client sat on the less dangerous drug. At what level, at what point should that be actionable behavior? Said, well, they saved a lot of money and it was going to take 7 to 10 years. But let's pretend that that other drug was available, but it cost $10 more. Are our citizens just out of luck?
No, Your Honor, they're not out of luck, and I'd like to expand on that answer on 2 prongs. In the first place, what we're looking at here is distinguishable from the hypothetical that you proposed, and not only in the fact of pricing, but also in whether or not there was some sort of malicious or fraudulent or egregious behavior going on here. In this case, the facts focused on in the causation element of both strict liability and negligence are one and the same. Yes, it's true, strict liability and negligence are different claims. However, they focus here on the same facts. And so if we take the same...
Don't run from the justice's hypothetical. I mean, we need to know, what if the conduct here was grossly negligent? Is there a cause of action for that?
Yes, Your Honor, that may indeed be allowed if there were in fact facts to indicate that it was grossly negligent. And that takes me to the second part of the justice's question, that if we were looking at such a case, then the facts would be fundamentally different. And even looking at Comment K itself wouldn't suggest that we need apply Comment K in that situation.
What cause of action would you apply in that case to get past summary judgment?
In theory, gross negligence might suffice. We're talking specifically about negligence itself as applied to the facts in design defect cases. And it's important to remember not just what is said in Comment K, but also the intent and the context involved in the drafter's creation of Comment K. Because, yes, it's true, Comment K does not include the word negligence, but to ignore the broader context of Comment K would essentially be to be putting on blinders and missing the larger point, because Comment K, as indicated by the drafters thereof, is specifically looking at this very type of circumstance where we're looking at design claims for drug manufacturing. They're not looking at other types of negligence or strict liability claims. They're focused specifically upon drug design claims, and that's because of the inherently unique nature of these types of claims.
Counselor, as I understand it, and I'm going back to what the appellant's counsel said in response to one of the questions, isn't it possible that a jury could conclude, if you didn't have this immunity process, by which the jury says, all right, this is not a defective design, rejects that claim because it does provide some utilitarian benefit, and the FDA has approved it. But on the other hand, could the jury not also, that same jury, conclude that the manufacturer was negligent because even though this does not rise to the level of being a defective design entirely, being FDA approved, but they could have done better if they had spent more time and money developing this new product. And they were negligent for failing to do that, and if they had done that, then their client would not have suffered this kidney damage. Tell me why that would be intellectually repugnant for a jury to come to a conclusion like that.
Your Honor, in this type of circumstances, it would be inconsistent for a jury to reach that conclusion because we are looking, again, at the same set of facts. And there is an important distinction to make here. On the one hand, with strict liability, yes, it does focus on products, but that is one and the same with the alleged conduct here, that the conduct in theory was that they should have gone with the different design. But that raises another important point of being the potential safer alternative design, and that is a burden which rests upon the petitioner for them to show that there is a safer alternative design. However, in this case, that has not been shown. All that has been shown is that there are two drugs, both of which were indicated by the FDA that they would have been approved for development and distribution. Both of those were provided to the FDA with all the same facts that we're talking about here today, and the FDA came down with the conclusion that both can be distributed to the general public.
I thought the record, could be wrong, but I thought the record reflected that the FDA had said they could go either way and would pursue the approval process either way, but your client decided they wanted to go with the more dangerous and less expensive product.
Not precisely, Your Honor, and that is a flaw with petitioner's characterization of the case in characterizing this as a blatant money grab, something to pad the pockets of Fuse-Meyer Pharmaceutical. That's mischaracterizing their intent here. Looking at the facts, we can see, specifically pointing the court to pages 5 and 6 of the record, there are two versions of the drug that were in development, Targetol and Targetol Next. Targetol was the one which was ultimately manufactured and distributed. Targetol did have a 1 in 100,000 chance of someone developing serious kidney side effects, as is what happened to Mr. Whiteberry. The other drug, Targetol Next, had a 1 in 200,000 chance of that happening, cutting it only by half, but also
fact-based analysis, and by the lower court granting summary judgment on the law and you asking us to adopt that, petitioner's never going to have a chance to present those facts?
Not necessarily, Your Honor. This is certainly something which would be included in the lower court's analysis. If it
Blanket immunity, that's as a matter of law. Prescription drugs have blanket immunity. So under your analysis, it wouldn't matter if it was 1 in 10 or 1 in a million. If the FDA approved it, there's immunity.
And that really gets to the underlying concern that the drafters of Comment K had, in that there really is no way to be entirely sure that drugs aren't and quote, unavoidably unsafe. There's always going to be a chance not only that drugs have some inherent side effects, but also unforeseen side effects, because each of our bodies will interact with a drug somewhat differently. And this extraordinary level of unpredictability, if it were to be held, would carry over into a form of liability for pharmaceutical manufacturers, would have a chilling effect upon innovation in this area.
So is that really any different from other products? If we took a car, for example, an airbag has some unforeseen, unsafe consequences, but we still allow it, and if a car designs it negligently, we still allow a plaintiff to make a claim. So how is that really different?
Your Honor, to answer your question, I'd like to distinguish one of the cases which was relied upon by the dissent here and gets the fundamental flaw in both the dissent's view and also that of petitioners. And that case that I would like to distinguish is Gonzalez versus Caterpillar Tractor Company. That's a Texas Supreme Court case from 1978. They're involving the allegedly defective manufacture of a tractor. If you take a tractor or a car or a washing machine and you manufacture those in some other way, they're still a tractor, a car, and a washing machine, respectively. If you take Targetol, or a drug which is defined by its unique chemical ratios, you no longer have the same drug. If you make Targetol with a different ratio of its chemicals, it's no longer Targetol. It's not even a safer alternative design. It's a different drug entirely. And in that sense, that sort of reasoning, which was heavily relied upon by the dissent, shouldn't be found persuasive by this court. They're too...
But doesn't that not apply here because there was an alternative? Like even
It
if you
was
had to
safer.
change something, sorry, go ahead.
That was safer.
Yeah, and it was safer. There was an alternative. It's not. It wouldn't have changed the entire composition of it. So, how does that reasoning apply here?
Because, Your Honor, it wasn't merely the safety that was part of Fusemeyer and indeed the FDA's analysis in determining whether or not these drugs should be distributed and developed for sale. There were other factors as well. The one thing is that technology had not yet caught up to the point where the more advanced version, Targetol Next, which was marginally safer in that particular set of side effects, not others, as was mentioned by my co-counsel, but the technology hadn't made that effective yet. And there's also another side to it. Respondent doesn't shy away from the fact that price did make some part of Fusemeyer's analysis. This court has never held that it's criminal for companies to make a profit, but to characterize that as the only or even the most important part of Fusemeyer's consideration here would not be accurate, but indeed it was an important part. Targetol Next.
So, what was the most important consideration when choosing that specific drug over the safer one?
Your Honor, because safety is indeed relevant, is indeed relative. Safety for one person, yes, 1 in 100,000, but if you take the other drug, you have, admittedly, less serious side effects, but you have them much more common because you require less effective, more common dosages, and it's simply a balancing act. And when Fusemeyer analyzed all of the factors together, they reached the conclusion that Targetol was the best option to go with. And if we allow Fusemeyer and other pharmaceutical companies conclusions confirmed by the FDA, no less, and learned intermediaries like Mr. Whiteberry's doctor, to go second-guessed in the courts, this would again result in a level of unpredictability.
Do you agree with me that if we accept both of respondents' positions and hold that application of comment K is a complete bar to design defect claims either arising under strict liability or under negligence, that essentially what we hold today as a matter of law will be that no prescription drug product can ever be unreasonably dangerous under Texas law? Is that accurate?
If we're talking specifically about design defect, then yes, Your Honor. That doesn't reach to manufacturing defect or even marketing defect.
Manufacturing and marketing defects ask whether a drug is unreasonably dangerous? Don't those address different questions altogether?
Yes, Your Honor, that's true.
Law in the state of Texas, if you're right, no drug can be unreasonably dangerous.
Yes, Your Honor, and that is looking at the plain language of comment K and also the broader context, which would show that the logic from strict liability would naturally flow also to negligence. Yes, that is the...
K, plain language doesn't say no drug. It doesn't say all drugs. It says some or many, which one of the other justices pointed out earlier, correct?
That's true, but in the application of Comment K over the years, and I would also point to recent precedent from local Texas federal courts, such as Monsibes versus Pfizer Incorporated, which is a U.S. District Court from the Southern District of Texas in 2021, in the application of Comment K, it becomes more clear how that logic applies. Because both causes of action depend upon a showing that the defective product caused the injury, the negligence claim fails as a matter of law. Your Honors, if petitioner to prevail here, pharmaceutical manufacturers would effectively be forced to choose between practicality and perfection. This would make effective drugs like Targadol no longer as affordable and accessible to Texans. This cannot stand. And for this reason and those aforementioned, we urge this court to affirm the decision of the 15th District Court of Appeals. Thank you.
Thank you, Counselor. Petitioners, your rebuttal.
May it please the court. Your Honors, I have 1 point and 1 point only on rebuttal. The FDA holds drug manufacturers accountable to the government. Shareholders hold drug manufacturers accountable through stock price and dividends. But what about a Texas citizen's right to hold another party accountable when they're harmed? The respondents are simply disguising their preemption arguments as policy reasons when they ask the court to defer to the FDA's judgment. They're asking for an unorthodox and extreme position, to be immune from suits in Texas simply because they are a drug manufacturer. When Texans are able to be heard in a court of law, it helps to build the credibility that they have in the systems in place to keep them safe. For example, we have the COVID-19 vaccine. There you have a life-saving drug that Texas citizens refuse to take because they don't trust the federal government and they don't trust drug manufacturers. If Texans aren't able to have their day in court and hold drug manufacturers accountable, their distrust of pharmaceutical companies and drug manufacturers will only be made worse. They will continue to refuse to take their medicines for fear that they will not have any recourse in a Texas state court. And for that reason, and for all other reasons previously mentioned, we ask that you reverse the decision of the 15th Court of Appeals so that Max Whiteberry may be heard by a jury of his peers. Thank you.
Thank you, Counselor.
Very nice.
Now the time comes for the panel to look at the outcome. And we are going to have a breakdown for that purpose. The panel will recess to another room. And
Please be seated.
Okay, Dan, I know you're waiting for a decision of the court, but you have to wait some more. The competition has been very successful. I am impressed, as I am every year, with the moving parts. There's so many, and how they go so smoothly for the competition. The Fagry drinker competition here in the spring, and of course the cross and sod competition in the fall. This competition has been no exception, and all of the work of the logistics and the like goes to our Harvey and Ritchie Moot Court Society offices, and there are Stone Martin. Did you stand up, Ritchie? Stone Martin. Danny is not here today. Danny, I'm right there. Emily is not here today. Emily Mauser and Duncan Robinson. And then also, Nicholas, where are you? Nicholas McHenry. Yeah, Nicholas is not a officer. Of course, he is one of our colleagues on the faculty as their associate, transactional associate. I could not help but know and notice that Nicholas was always there for whatever needed to be done. So Nicholas, special thanks to you as well. Helping the competition go so smoothly. Let's get them all. Students meeting on Part 3, legal analysis, research, communication, Part 3 as we call it. And I want to acknowledge and thank each of my colleagues who have this past quarter taken a section of Part 3 class. Professor Stephanie Kang. Professor Jessica Asbridge was here, I noticed during the arguments, and then also Professor Greg White, Jim Medeiros, Leanne James, Chris Koletska, and Mike Berry. Mike, can you stand up, please, and come forward? Come here. When the boss says come. Along with the officers of the society, Professor Berry, year after year, does a marvelous job in this competition. Not only do all the parts work so smoothly, but the problem, we're all persons who know there was a problem. Every year, it is remarkably crafted, complex, balanced, and therefore fair, as well as challenging. And that's the result of Professor Berry's work every year in drafting the problem. He tests it, he runs it through focus groups, through focus arguments, and he makes sure that everything is just right for the students, which is so important. And I also want to note that I appreciate, no, you're not. I so appreciate what Professor Berry does, because he always crafts a problem that is quite challenging, and yet at the same time it is accessible to our first-year students. So often in competitions at schools around the country, first-year student competitions, the problems that are used are problems that deal with securities regulation or environmental law and the like, and it's all fine, but it's very important that our first-year students get an opportunity from towards class in this case to really grapple with the concepts that they have learned in their classes during their first year in law school. And Mike always achieves that with excellence. Also, I always want to share that I shared, there have been a couple of problems dealing with pharmaceuticals, and I want to share this one that seemed like it was written by an expert. Yeah, it did. Professor Berry had a life before law. He was a pharmacist, and so he wrote the problem with a special insight and expertise. So I think.
argument today, wasn't it?
Definitely.
It was.
Yeah.
Yes.
A Baylor law advocacy, very proud. The court will announce the winner, and then, don't leave, we have the speaker awards and some other announcements from the officers of the society. And when we finally do adjourn, make sure that you clean up the snacks. All right, and with that, Chief Justice.
Thank you, Dean Tobin. The winner of the final round is the respondents.
May it please the court. Thank you guys so much for coming out and participating. For many of you coming to judge for y'all, really appreciate everyone's cooperation and responses to all my countless emails I sent everybody over the course of the past few weeks. So to start, I first want to recognize our semifinalists who made it to our semifinals on last Thursday. So starting with that, please come down and get a plaque we have for you whenever we say your name. So first, Cameron Dow. Melanie Green. Asna Poonawalla. And Antonio Pana. Congrats. All right, and now we have plaques for our semifinal or our second place and as well as our winners. So please stand up and go get your plaque. Aquila Jones and Rachel Brooks. Thank you. Kelton Munch and Kingry Solons. Yeah, so now the formalities of pictures, now or later?
We'll take them outside into the Mad Dog stand.
Okay, sounds good. You guys may be seated if you'd like. All right, and in addition to our competitors that have made it to the semifinals and finals, we'd like to recognize our Exceptional Oral Advocacy Awards. And so I will recognize the top 3 in order after I recognize 4 through 10. 4 through 10 will not be said in any order. They will just be deemed to have received oral advocacy honors. So starting with 4 through 10 in any order, Paul Gunderson. And 4 through 10, if y'all just want to stand up in place. 1st through 3rd we'll have. Thank you, Paul. Deja Bryson. Camille Calloway. Alexis Pineda. Anderson Tittle. Brendan Fowler. And Kelton Munch. All right, now for the top 3, when I say your name, please come down and get a plaque. Beginning in 3rd place, we have Garrett Welch. Second place, Asna Poonawalla. And our first place speaker this year was Walker Montjoy. Perfect. Well, thank you guys so much again for everything, and hope you enjoyed it, and have a great rest of your day.
And once more, thank you to Frederick Pinker for sponsoring this competition, for the Royal Field Law School, and also also want to thank Ms. Richards and Ms. Underwood. I've not gotten used to it, it's no longer Underwood.
No, it is.
Oh,
I kept it.
in that case, never mind, except for the thanks. And Catherine and Maria, thank you for judging today, along with your panel. This has been a big success, and each of you have learned so much from this opportunity. I know I've talked to some of you, especially when you go up to the practice round the day before, you're so nervous. And then you find out that, hey, I can do this. But then you also find out that, hey, I can get better step by step. And that's one of the beauties of advocacy. Nobody in the art and the science of advocacy has ever arrived. You can always get better. And that is a real blessing for all of us lawyers. So to the firm and to our justices, thank you so much. And we are now adjourned.
Nice to meet you.